Hi, everyone. Good afternoon. Today is September 9th, 2020, and I wanted to do a quick review summary of Chapter 1 for Family Law. It's got a lot of important stuff there, but it's more of a foundational chapter talking about the history of family law, uh, rights of people to marry, and rights of people generally in terms of their status. Women, minorities, children, they very much had different status throughout not only the history of America, throughout the history of the world, and that has changed quite significantly, certainly in the 20th and 21st century. And but it's interesting to know what the roots of our um, legal system are regarding family law and the status of women and children, and how it's evolved to, at least in the eyes of the law, to be equitable and equal. And we'll get into that. Let's talk about marriage right off the bat. Not everyone can marry. There's been the real controversial issue that I think that still remains today regarding marriage is many see it as a religious institution, that it's ordained or a sacrament of someone's faith. And it's the religious churches and organizations and I don't always call it a church because it depends on the nature of the religion, what you call your sort of your center of faith and where you would go. But many of us think of the sacrament or the concept of marriage as a religious institution. Well, it does have its roots there. But the government, centuries ago, started getting involved in the interest of whom may get married and whom might not. Some of it legitimate and some of it illegitimate, or arguably illegitimate. So today, what's important for most of us that are going to be paralegals or attorneys or just interested about basic civics, we want to know those limitations on marriage. And we knew for a long time, right up in the 1960s, there were limits on marriage for interracial couples. The famous case called Loving v. Virginia, I believe it's been made into a movie. It was illegal for people of two different races to marry. And this white male and African-American female wanted to marry. They fell in love and they defied the law, and they were both going to be punished by, I don't know if it was a significant fine or a short stint in jail. And they created it as a test case. They purposely did this to defy the law because they wanted to challenge it, saying it was unconstitutional. And the state of Virginia defended, saying the determination of the validity of marriage has always been a states' rights question, and the federal government has no bearing in it. But what the parties argued was, but you're being discriminatory. And Virginia, if you read the case, it's kind of interesting, tried to argue, no, we're not being discriminatory. We treat whites and blacks or African Americans exactly the same in our law. They'll both be punished for doing this. But it obviously is discriminatory because it's taking an identity of race and giving lesser or more rights depending on your racial identity. And so this couple, again, a mixed marriage, for lack of a better way of saying it, they challenged the law, and the state of Virginia was determined you were discriminating. Well, can government discriminate against people? Well, sometimes, but they have to have what? They have to have a valid, compelling, bona fide reason for doing so. And their bona fide, valid reason for doing so, argued in court, was the purity of the races. Totally invalid, unacceptable argument. In that case started, I think it's 1967, basically struck down this concept of equality in the eyes of the law for marriage rights between different races. Any race can marry any other race. But did other preclusions still exist? Yeah, there's still preclusions to this day, but the big one I'm obviously referring to is gays and homosexuals and lesbians, depending on the terminology that's appropriate, were barred from marriage. And the real striking first case came right here in Massachusetts. It's a case called Goodrich, and one of the litigants was actually a law professor at the law school I went to. I never had her as a faculty member, but she was one of the litigants. She and her partner wanted to get married. They sought a marriage license, and they were denied it. They said, no, only one man, one woman can marry. They have to be 18 and of competent mental standing. So they challenged it, and it didn't go to the federal court, it went to the state of Massachusetts Supreme Court, our highest court on state law. And again, most family law, up until the past couple decades, has been really derived out of state law and state jurisdictional questions. So they didn't think of, I don't know if they thought of it, but they thought their avenue of redress would be through the state constitution to fight about the state of Massachusetts constitution. Maybe protecting their interest as a lesbian couple should have the access to marriages as a heterosexual couple could. And the arguments are fascinating before the Massachusetts Supreme Court, because those that wanted to maintain the restriction that it'd be only one man, one woman, tried to argue that marriage is for procreation and to produce other children. And that quickly got shot down by members of the Supreme Court justice inquiring about people who are infertile or people who wish not to have children. Should they be barred from marrying? And of course, the litigants said no, they shouldn't be barred from marrying, and thereby defeating the logic of their argument that it was for purposes of procreating in a family situation. And their arguments also went to the question of it's a religious institution that's always been recognized as one man, one woman. Well, we have separation of church and state. The Supreme Court of Massachusetts says if gays and lesbians are an identifiable group of people, all groups of people have the same inherent fundamental rights. And then they went through an analysis of whether or not marriage is a fundamental right. And it is, according to the Supreme Court of Massachusetts. So therefore, gays and lesbians of the right age and mental competency should have the same fundamental rights as everybody else, including the right to marriage. So Massachusetts kind of opened up the floodgates. Other states came down with similar rulings. Other states came down with very controversial, I shouldn't say controversial, but very contradictory rulings, saying just the opposite. It's only one man, one woman. And some states, the southern states, actually put in constitutional amendments in their state constitutions, making it perfectly clear the only people eligible to marry in their state would be one man and one woman. So initially we had this very confusing hodgepodge of states that allowed gays and lesbians to marriage, others that banned it outright, others that would recognize it from other state, like Rhode Island, for example, for a period of time would say, if you get married in Massachusetts as a gay or lesbian couple, we'll recognize it as a legitimate marriage in our state. But here it really got complicated. But if you want a divorce, we can't give you one because we can't undo a legal arrangement that we don't recognize at its inception. So you'd have to go back to Massachusetts and divorce. And this really crazy case happened where this lesbian couple got married like many couples, and they decided to get a divorce like many couples afterwards. They tried to get divorced down in Rhode Island. Rhode Island says, we can't give you a divorce because we don't recognize that as a marriage of inception from our state. You have to go back to Massachusetts. At that time, Massachusetts had this rule. They had to be a resident of the state of Massachusetts for 1 year to seek a divorce within the state. And they said, hey, well, we don't want to move to Massachusetts. We just want a divorce. And so it created this very significant set of conflicts of laws throughout the country, including the federal government. Is the federal government going to recognize you under tax purposes for being a married couple or not? Because it's not a federal standard. And so we really had a very difficult situation going on in the country for a period of time. And some states were allowing gays and lesbians to marry statutorily, and then later the statute would be undone and be repealed. And gays and lesbians had to really had to do forum shopping on what community they wanted to live in order for them to exercise what they believed to be their right to marry. It all changed in this case. I always pronounce it incorrectly, so I'm just going to go to my cell phone because I have it right on my Google search. It is Obergefell versus Hodges, and it's a 2015 case. In terms of law, that's pretty fresh. It's 5 years old. That case, I don't know what state it came out of, maybe California, but basically they took the case to a federal court. Now, usually this is state law stuff, family law, state law, so the federal court shouldn't have any jurisdiction over it, but they raised an issue under the 14th Amendment, and this is covered pretty extensively in your chapter. The 14th Amendment says no state can deprive its citizen of due process of law or equal protection of law. And that's been interpreted as saying no state can basically deprive its citizens of fundamental rights unless it has a very compelling interest, purpose behind it. And so when it got to the Supreme Court, the very similar argument of the Goodrich case from Massachusetts was argued on the federal level under the 14th Amendment, saying because gays and lesbians are human beings and are an identifiable group of human beings, they should have the same equal protection and equal process under the law as heterosexuals do, thereby arguing that they should have the right to marry. And in a split decision, but a majority decision nonetheless, the Supreme Court said yes, gays and lesbians who are of competent mental understanding and of age in their respective jurisdictions can marry. And therefore now throughout the United States, all 50 states, gays and lesbians have the right to marry. So DOMA, the Defense of Marriage Act, which was a federal act that was endorsed by President Clinton, which is a little bit surprising because a lot of people think of him as a progressive and a liberal. He endorsed it, saying states could discriminate against another state's marriage if they found it repugnant to their home state. So if Mississippi didn't like the fact that Massachusetts recognized gay marriage, Mississippi wouldn't have to recognize that party, that couple, as a married couple in their home state if they were to go reside there. And that created a lot of conflict. But DOMA, the Defense of Marriage Act, is now deemed unconstitutional. It's null and void. It's gone. Gays and lesbians throughout the entire country have the same marital rights as heterosexuals. What's interesting about that is a lot of people, when it first happened, it still remains controversial in some people's minds. A lot of people say, oh, what's next? And my friends, I have some friends who aren't lawyers, and I don't know what they do on the internet, but they're involved in, I don't know if it's on Facebook or whatever it is. They see look, this woman married her car. This guy wants to marry a tree. It's nonsense. There are still significant restrictions on what person you can marry because it does protect the public interest. For example, you can't marry someone, or we can't acknowledge the legitimacy of a marriage if they're underage in most jurisdictions. And those jurisdictions are somewhat different. There's an age difference in some states that are different than others. And then there's some caveats that, like, for example, in Massachusetts, I believe you have to be 18, but you can get court consent and you can also get parental consent if you're under that age. And how low it can go, I don't know, because I've never had a case dealing with it. But you can see the government's interest in saying people should be of a certain age in order to marry. And they also need to be of a certain mental capacity. It's a very low threshold what mental capacity is. You don't have to be the sharpest knife in the drawer or anything like that. You don't have significant education. But we want people to understand the nature of the obligations that they're entering into when they marry. So you have to be basically mentally fit to do so. Very, very low threshold in law, though. In fact, it's a presumption law that everybody is competent until proven otherwise. So that's another limitation on marriage. Age, competency. Oh, and the other is you have to be single to get married. I know it sounds kind of silly, but bigamy is quite common. It's usually accidental. I've actually been involved in a few cases where somebody, usually not as a lawyer, but just as somebody wants to tell me their woes. I had a couple women come into my office and told me about her boyfriend, and she was, oh, how's it going? And wedding's coming up, and she was all excited. And she goes, well, yeah, I'm not getting married now. My fiance is married to somebody else. And it was one of those things. We got married maybe 7 or 8 years ago, just before he went into the military. Got married maybe a month before. They broke up while he was away overseas. Never really talked again. When he came back, she wasn't living there. They don't know where each other. They probably know where each other was, but there was no contact anymore. So they just kind of assumed they had some sort of like divorce by assent or something. No, you have to get divorced legally. And occasionally that comes up in my own practice on the other end. I remember representing a guy. He was going to pass away, and I was doing his will, and I was with his adult son, who was my age, and talking to him. He goes, well, you're not married. He goes, well, yeah, of course I'm married. And I know this guy for a long time. I said, oh, is your wife alive? And he goes, oh, yeah, she's alive. She lives over, names a town, like 5 towns over. He goes, I haven't talked to her in like 40 years. And I talked to the son, and I said, what's going on here? He goes, yeah, my mom and dad got estranged in the 1980s. They haven't talked since, nothing. And I said, but guess what? They're still legally married. The only way to undo a marriage is death or divorce or annulment. We'll get to that in later chapters, what that actually means. So sometimes when couples do get married, one of the sort of the obvious thresholds is mental competence, right? The other is they have to be single in this legal sense. They're not married to somebody else, and any marriage with somebody else has been dissolved. I'm just looking through some of the chapter things here about it. Oh, all marriages are a contract. Be careful about that one. Yeah, it's a contract, meaning you have to have mutual agreement, mutual understanding. It has to be voluntarily entered into. We don't allow any kind of forced marriages. It has to be done knowingly. But it's not binding in the same sense. Like if I promise someone to marry me, and they in turn promise to marry me, that's the meeting of the minds. There's a contract there. We're both competent. We're both of age. Sounds like we have a contract. But what happens if, she meets somebody new on, I don't know how people meet, Facebook or whatever, and she goes, Jim, I found someone better than you. I'm hitting the road. I'll see you later. Can I sue for breach of contract? And the answer in almost every state is no. I can't even sue for monetary damages if I rented a hall and a band or something for the wedding rehearsal and incurred a lot of financial expense because through no fault of my own, she breached the contract. We don't want those kinds of cases coming before a court of law. In fact, there's a name for that kind of statute. It's called the Heart-Balm statute. Isn't that kind of, I always thought that was the coolest thing. The Heart-Balm statutes prevent you from suing a significant, another contracting party for breach of the marriage contract. You can't sue for it, even if you have financial damages. If you really think about it, it's probably a good idea that you can't. And why do we care about marriage? Why do people? Certain rights are inherently involved in marriage. So when you marry, you have a marital estate. You share assets together. You share rights together. You have automatic inheritance rights from the other spouse, even if there's no will upon death. You can potentially make medical decisions on behalf of a spouse who can't speak for themselves. There's a lot of rights that are inherently given to a married couple that don't have it if they're not married. And I don't want to spend a ton of time on it, but there's other things to do with like the way in which you own real estate. You can own a house by what's known as tenancy by the entirety. Only married couples can do that. What benefit comes from that is when one spouse dies, the other spouse automatically owns the real estate in its entirety. But even maybe more important to that is my wife goes out and causes a car accident, severely injures people, and she gets sued and they try to go after the house. They can't get the house unless it was a joint action between the husband and wife because we own it by tenancy entirety. We are one, and the only way to get access to what we own as one is it to be a joint enterprise in the behavior. It's kind of a nice concept in a way. There's certain protections that come from marital couples. I think I do a lot of criminal work. I just got back from the jail, as a matter of fact, and my client has allegedly assaulted his wife. And his wife wants to take the marital privilege, another privilege of marriage. Not just wives do it, but usually wives are the victims of the domestic violence. They can refuse to testify in a court of law. No other person generally can refuse to testify unless you have a special privilege, and that's a major one, is marital privileges. Spouses cannot be compelled to testify against each other in a court of law because we want couples to be able to freely discuss things without fear that they'd have to testify against each other in court. In fact, you're not even allowed to testify if you want to when it comes to the communications you've had back and forth. But the other is just, hey, my wife pushed me, or she stole money from me, or she did something terrible. I know of the facts and I could bear witness to it. I can invoke my marital privilege and refuse to testify against my wife. And I'm actually barred again from testifying about the things she said to me because we want open communication in a marriage without fear of that ever being divulged to anybody else. Even with consent. So communication's absolutely taboo, but other kinds of testimony are at the election of the party being married. But you have to be married. Now, what does it mean to be married? You have to be done through the correct solemnization process, meaning someone duly authorized to marry you has to be done. You have to pull a license from the town in which you're currently residing. There's no longer a blood test that there was for a long time, and that was, I think, to ensure that there was no diseases being communicated, maybe a way to weed out that in the community. I don't know. I just got remarried, and I didn't have to take a blood test this time around. But when you do get married, it has to be done through a licensed authority. My daughter just got married on June 6th, as a matter of fact. And guess who did the wedding? I did. I got a license from the state. It's called a one-day special license to be a justice of the peace. And I married her. Well, she wanted to have a more traditional wedding, but COVID hit, and she had to cancel it. But her and her husband were still eager to get married. I don't know why I'm laughing at that, as if it was like a mistake. He was a great guy, and she's a great girl. But they got married. It was just the three of us, actually. And one of my sons was there because he was living in the house with her, too. So we did an appropriate marriage. And you don't have to necessarily say too many magic words. It's more about the intent to be married. In fact, I have a letter here up at my desk, and I had to re-sign it. And this is my certificate of marriage of my daughter right here. And apparently, if you look down, I don't know if you can see color through this thing, I signed it in blue ink. It had to be signed in black. So my daughter thought she wasn't married, and sort of my son-in-law. And I told her, now it's time to run. You're out. You're not legally married. That's not true. We'll actually probably talk about that in some later chapters. If there's something called an impediment to marry, like a minor mistake like that, as long as the true intent of the parties were there in the core of the eligibility was there, they'll treat the marriage as valid from that initial date. So not that big a deal. So age of capacity, age of consent. Civil unions aren't nearly as important as they once were. They were at one time. That's basically you want to enter a contractual relationship with your significant other, but don't want to go through the formality of marriage. I don't know that many people that do that. I mean, you should know about it in terms of the concepts in the book, but it doesn't happen very much. And another issue with marriage that's very important, I know this is going long. When I see a video that's more than 10 minutes, I'm like, oh my God, I can't possibly sit through it. Don't watch it all at once. I know I'm boring you to death, but this is an important concept. If you live with another significant other, you have kids together, but you never get married, and then the other person decides, or both of you decide, hey, this isn't for me, let's break up. Well, when you divide the property, it's not marital property. So if one person has title in their name to the car or maybe to the house, you're going to have a tough time getting any interest in that property through a claim of marriage. It's not marital property. It's not going to be divided and separated under the principles that we get to, I think it's in chapter 8, on how we divide a marital asset. You're not married. And I had this happen in my law office one time. A woman comes in, and I know her husband passed away. And she was talking about how her sons are kicking her out of her house. And I'm like, what do you mean sons are kicking her out? What the heck's going on? She goes, well, they're saying that, my husband owned it. I'm like, yeah, but you were married, even if it's in his name. We'll get to that later. Just because it's in somebody's name, once you get married, it becomes a marital asset. The law doesn't really consider the fact that someone's name is on it as much as that it's part of a marital estate. It doesn't have to be bought during the time of the marriage. Just simply, it was something that existed. They lived there together for 25 years. Well, it turns out they were never married. So that's what I said. So let me get your marriage license together, and you're going to, by law, inherit significant portions of your husband's estate, even if there's no will, and even if his name was on the real estate alone, because you're his spouse. And that's one of the magic privileges of being married, is inheriting a significant portion of your decedent husband or wife's estate. Never married. And so the kids, even though they were her kids too, they wanted her on the house, they wanted to sell the house and get the money. They probably were legal in the right. I tried to bring up some arguments with them talking about that there was certain maybe contractual monies owed because she helped contribute to pay the mortgage over those 25 years with an expectation. I was trying to argue this quasi-contract theory to the kids, and they had a lawyer, and I knew him, he was pretty good. And we came up with a compromise because they were still kids, and we came up, but you got to be very careful. There are situations like that where people live together for an awful long time. One of them dies or one of them decides to move on, and they say, well, I want my share of the marital assets. There is no marriage. There is no marital assets to split. You take what's yours and what's mine. I know some of them are commingled, and they've really been shared in terms of the process of getting these assets, but without a marriage, the ability to argue that there should be a division of marital assets is totally foreign. You can't even go to the probate court because in order to divide marital assets, you've got to file for a divorce. You can't file for a divorce if you're never married. So the power of getting married is very significant. That's what chapter 1 is really trying to push forward. Cohabitation is no longer illegal. It was for a long time. And I think I might have it on the test question that sometimes I think it's called Lawrence v. Texas. And this is basically how they were actually caught. I don't know, but they got charged with homosexual sexual behavior in their own home. I don't know how it was proven, but they got convicted and they brought it to the Supreme Court. And the Supreme Court said, you know what? He goes, the laws of the states really shouldn't go into the privacy of one's home if there's no government interest in play. And so it basically did away with the laws banning cohabitation. But up until that case, in theory, it was illegal in many, many states. In fact, it probably was on the books here in Massachusetts that it would be illegal to have a sexual relationship with somebody you cohabitated with without entering into the bond of marriage. Society at one time thought that was very important, had in the books, but over time we've recognized that many people cohabitate without the intent to marry, and maybe it shouldn't be illegalized. And a lot of people think, well, the laws are not promoting it. Well, they're not promoting it. They're just basically saying, we're going to stay out of the bedrooms of consenting adults, and they do. So cohabitation is no longer legal, but no rights inure to you as a result of cohabitating with a significant other. It's an important concept. And that's when you try to bring up the implied in fact contract, and you say, well, geez, I lived with this woman for 30 years. I know the house was in her name. We never got married. I paid some of the mortgage payments sometimes. I helped, paint the side of the house a few times, and I'm the one that paid for the roof, 6 years ago. Don't I have a quasi-contractual right to get some of the equity out of that home upon the breakup of a relationship? The law doesn't like it, because the law says if you really wanted those rights, you should have married. But those are the arguments that we bring up. I'm trying to look at these other age of capacity. Polygamy. There is no, I get this argument with students when I teach this class in a traditional brick and mortar, that they argue that there's places out in the southwest part of the United States, Utah, for example, that polygamous marriages are allowed. No, they're not. There's nowhere in the United States of America that polygamy is legal. Now, is there some maybe communities that don't really frown upon it? I don't know, perhaps. Are there some maybe jurisdictions that aren't going out investigating polygamous relationships? Perhaps. But you can only have one legal marriage at any given time. Even if people are saying, hey, these are my 3 wives, you have 1 wife and you have 2, I don't know, 2 girlfriends or something, I don't know. And vice versa. If a wife can, these are my 4 husbands, and she has 1 husband and 3 boyfriends. Probably unethical and immoral. And no longer really illegal in Massachusetts. A lot of people don't know this. We'll get to it in a later chapter. Adultery has been in the book and it's felony in Massachusetts up until about 2 years ago. They did away with the crime reform bill in Mass. It's no longer a crime to commit adultery. Most people think, well, it should be. But at the same time, do we really want law enforcement going out investigating whether someone's been, in an extramarital affair? So we'll get to that in a later chapter because it's no longer used really as a fault ground in divorce. It can be, but it doesn't give you any benefit. Community property, we'll talk about that when we get to division of marital assets. We are not a community property state. We're common law, so meaning that it's not an equal division of marital assets. It's equitable, depends on the nature of who contributed what, how long you're married, who did what to raise kids. It's a very complex formula in Mass. Community property is everything that was gained during the marriage, 50-50 split, everything that was brought in before the marriage remains that person's property. It's an easier formula to figure out, but it has complications to it. But we do not live in a community property state, so it's mostly in the south and the western part of the country. Equal protection clause, and we know women's rights have come a significant long way. In fact, after I got married last year, October, one of my favorite movies is called It's a Wonderful Life. If you haven't seen it, I want you to catch it this holiday season. It's an old movie. My kids hate it because it's in black and white, because I think anything in black and white can't possibly be entertaining. But in the movie It's a Wonderful Life, it's the city in the landscape that was motivated, and Frank Capra, the director and producer of the movie, was Seneca Falls, New York. And so, because I'm a junkie for It's a Wonderful Life, my wife decided to take me up there for 3 days. Ironically, it's also the home of the women's suffragette movement, with the first women's constitutional convention in Seneca Falls to fight for women's rights. I believe it's in 1848. And so I got to go to that museum as well. And it's really remarkable when you think about how recent women have been deemed equal in the eyes of the law. They've only had the right to vote for 100 years. We're celebrating it this year, as a matter of fact. But in law, for a long time, it's more of a novelty. I mean, I'm not going to test too much on it, but women couldn't be in a marriage, if they were married, couldn't be the victim of an assault and battery by their husband or a rape, because legally they became one. And really horrendous second-class citizenship for women in our country, no question about it. But that's all changed now. The law, at least on paper, and hopefully in its attempt to apply it, is equal. Whether you're a man, a woman, a gay, a lesbian, in your race. We hope the law, and that's why, Lady Liberty, when I think about Lady Liberty, that statute, I collect all kinds of political and legal memorabilia, got all over my office. I always admire the scales that have Lady Liberty with a blindfold over her eyes when she's holding the scales of justice to figure out what was fair, what was appropriate, what was just. The reason for the blindfold is equal application on the law, regardless if you're old, young, male, female, a person of color, a Caucasian. It shouldn't make any difference in the eyes of the law. It's applied equally and fairly. That's our hope and that's our aspiration. And we've come much further in making that happen. And hopefully Chapter 1 brings that out. Polygamy, incest, that might surprise some people in Massachusetts. You can actually marry your first cousin. I'm not going to get too deep into the rules, but we know the government does have an interest in preventing, brothers and sisters and mothers and sons and daughters and fathers, and the possible combinations. Too closely related, there is not only a moral interest for government to ban it, but there's also a biological outcome of children of incestual relationships that can be very traumatic. So I just want you to keep that in mind. Sorry that my phone was on. So that's pretty much Chapter 1 in a nutshell. It's got a ton of stuff in there. Although if you have the reason why I said in the syllabus, hey, I want you to get Volume 6, hopefully to save some money, If you have volume 7, it's really the same book except new information really about the death of Doma and the Ogelberg and Obergefell, I should say, in Hodges' case, basically making the right to marry for gays and lesbians uniform throughout the country. I do want you to read the Loving Virginia case. It's beautifully written by the court, and I believe I also asked you to read Goodrich in the back of your chapters. But hey, keep the questions coming. I'm here just to be kind of a conduit. This book is fantastic. I believe she teaches at UMass, this Shoshana Ehrlich. It's a great book. If you haven't got it, this is what it looks like. I think even the new edition looks kind of like that. Great resources. Don't be afraid to shoot me an email, give me a call, whatever you need to do to communicate about questions you might have about this book. Otherwise, thanks for the patience. I know it's a long video. Break it down into parts. Do other things while it's playing in the background. Pick up on the things you think are important. Thanks.